Welcome back to the Deep Dive. Today, we are getting into something truly foundational for corporate finance and compliance, the legal framework for how companies in India raise their capital.
Welcome to StudyVic's YouTube channel. Always study smart and master your future.
We're doing a deep dive into Chapter 3 of the Companies Act, 2013, specifically Sections 23 all the way through 42. This is the complex world of the Prospectus and Allotment of Securities.
That's right. And for you, the learner, especially if you're preparing for exams like the CA Inter, mastering this isn't just an option. It's non-negotiable.
Absolutely.
Okay.
So our mission today is to go beyond just reading the sections.
Right. We're going to put on our CA teacher hats and really extract the core legal provisions. We want to look at the precise compliance workflows and, maybe most importantly, identify the liability traps that come with issuing securities.
And the big theme, the thing we keep coming back to in this chapter, is that tension, isn't it? The balance between letting businesses get capital and, well, protecting investors from getting burned.
Exactly. It's all about that balance. So we'll give you that structured analysis starting right at the beginning with Section 23. Let's look at what options a company actually has to go to the market.
Okay, so Section 23, this is the big fork in the road, right? It immediately separates the world into two camps.
It does. It all comes down to one thing. Are you a public company or a private company? That single fact changes everything.
Well, let's start with the public company. They have the full toolkit available to them.
The full arsenal, yes. The most obvious one is the public offer. This is what everyone thinks of, and it's heavily regulated by SEBI and the Companies Act.
And public offer isn't just one thing. It includes the IPO, the initial public offer.
Correct. That's the first time a company offers shares to the public. Then you have the FPO, or further public offer, for any subsequent issues.
And there's also the offer for sale, the OFS. That one's a bit different.
It is, because technically the company isn't raising new capital for itself. It's existing shareholders selling their shares to the public. But for regulatory purposes, it's treated as a deemed public offer.
Okay, so beyond the public markets, a public company can also do things like private placement or rights issues.
And bonus issues, yes.
Yeah.
But here's the crucial point, the immediate restriction. How is a private company different?
They're boxed in.
Completely boxed in. A private company is absolutely 100% prohibited from making a public offer. Full stop.
So their only options are
Rights issues, bonus issues, and private placement. And that private placement has to follow the super strict rules of Section 42.
that prohibition on public offers is really the defining feature, isn't it? It's the legal firewall.
It is. It's the wall that protects the wider public market from companies that aren't ready for that level of scrutiny and disclosure.
So just to play this out, what happens if a private company messes up? Say they accidentally target more than 200 people, they put an ad out. Is it just a fine?
Oh, it's much more severe than that. It's not just a slap on the wrist. If a private placement breaks the rules of Section 42, goes over the 200-person limit, advertises publicly, the law reclassifies the entire thing.
Reclassifies it as what?
As a public offer. And that immediately throws the company into a compliance nightmare. Suddenly, they need a prospectus. They need to meet minimum subscription. All the liabilities kick in. It's a disastrous reclassification.
Wow. Okay, so that really drives home why the rules are so strict. Now, before we go deeper into raising capital, we need to be clear on what we're talking about. What exactly is a security?
Right. It's not just shares and bonds, which is what most people think. The definition is really comprehensive. It comes from the SCRA, the Securities Contracts Regulation Act, and the Companies Act adopts it.
So give us the scope. What's included?
Well, the traditional things, of course. Shares, debentures, derivatives like futures and options, and government securities.
But it goes wider than that.
Much wider. It has to cover things like structured finance. So it includes units from collective investment schemes or CIS and from mutual funds. Basically, if it's an investment where your profits depend on a pool of money managed by others, it's a security.
I remember the source material mentioned something specific from the Sarfisi Act. Security receipts. Why call those out?
Ah, that's a great point. Including things like security receipts is crucial for modern finance. Think about it. A bank bundles up 1,000 home loans, a pool of debt.
Okay.
Then a special entity, an SPDE, issues certificates that give investors a right to the cash flow from those loan payments. That certificate, is it a security?
It represents an interest in the underlying debt. So
Exactly.
Yeah.
And the law makes that explicit. By including them, it ensures investors in these complex securitized products get the same protections, the same disclosure standards, as someone buying a simple share in a company. It closes a big regulatory loophole.
That makes a lot of sense. But then there's the big exclusion, the one that causes a lot of confusion.
Yes. For the removal of all doubt, the Act is very clear. Securities shall not include unit-linked insurance policies, ULAPs.
Why not? They look and feel just like an investment product.
They are, but they're primarily insurance products, and they're already heavily regulated by a different body.
The IRDI, the Insurance Regulatory and Development Authority.
Precisely. The law wants to avoid regulatory overlap. You can't have SEBI and the IRDI both trying to govern the same product. It would be chaos. Since ULIPs are already covered by the Insurance Act, they are specifically carved out here. It's about clear jurisdictional boundaries.
Clarity on the instrument defines the regulator, and clarity on the company type defines the method. Okay, that's the foundation. So who actually enforces all these rules? Let's talk about Section 24.
Section 24 lays out the division of power. It's a split between SEBI, the Securities and Exchange Board of India, and the more traditional bodies, the central government, the Registrar of Companies, or ROC, and the NCLT.
The tribunal. So where do you draw the line? Where does SEBI's power end?
SEBI is the capital markets regulator, so its power covers the issue and transfer of securities and non-payment of dividends. But, and this is the key, only for listed companies or companies that are about to be listed.
So an FPO for a listed company, that's SEBI's territory.
100%. They'll scrutinize the prospectus, the disclosures, everything. Their mandate is the integrity of the public market.
So what's left for the ROC and the tribunal?
Everything else. All the internal, structural, corporate actions, things like filing the return of allotment or the procedure for changing the company's objects, and the really critical example, the redemption of preference shares.
Wait, even for a listed company, that seems counterintuitive. If a company listed on the stock exchange wants to redeem its preference shares, SEBI isn't in charge.
No, because redeeming preference shares isn't a market transaction in the same way an issue is. It's an internal capital restructuring. It's about balance sheet management, following the rules for the Capital Redemption Reserve.
Which are all defined in the Companies Act itself.
Exactly. And the Companies Act is administered by the ROC and the NCLT. This distinction is a classic exam question, by the way. It really tests if you understand that SEBI's power is tied specifically to the market-facing aspects of issue and transfer.
Got it. That clarifies the power structure. Now let's talk about the central document for any public issue, the prospectus. Section 26. What are the absolute must-dos before it goes out?
The first step is non-negotiable. Before a single copy is given to the public, a signed copy must be delivered to the registrar for filing. This is the moment it becomes an official legal document.
And who has to sign it?
Every single person named as a director or proposed director. The law wants to fix personal accountability right at the top.
That sounds like a logistical headache if directors are all over the world.
It can be. The law does allow for a duly authorized attorney to sign on a director's behalf. So, if Director Sarika is in London, she can give written authority to Gautam in Mumbai to sign for her.
But does that let her off the hook if there's a misstatement?
Absolutely not. It's a proxy for the physical act of signing, not for the liability. The accountability still rests firmly with the director whose name is on the document.
Okay, let's talk about protecting investors from what's in the prospectus. It's full of expert opinions, valuations, engineering reports. How do we know the experts are independent?
The Act is very focused on this. First, it defines an expert pretty broadly under Section 238. It's not just CAs and company secretaries, but also engineers, valuers, anyone authorized to issue a certificate.
And how does a director prove they justifiably relied on one of these experts if something goes wrong?
A director can have a defense against liability if they can prove they relied on an expert they had reasonable grounds to believe was competent. But there's a huge catch.
Which is?
That defense disappears if the expert withdrew their consent in writing before the prospectus was filed with the registrar.
Why is that timing so important? Before filing?
Because it creates an unbreakable paper trail. If an expert realizes their valuation is being misused or is no longer accurate, they can pull their consent. Doing so before filing puts the company on notice. It forces the directors to check right up to the last minute that all their expert backing is still solid. It's a powerful safeguard.
Okay, so that brings us to maybe the most fundamental question in this whole chapter. What does public actually mean? The entire weight of the prospectus rules hinges on whether an offer is made to the public.
It does, and this is where legal interpretation really matters. The Act says public isn't just the public at large. It includes any section of the public.
Any section? That's incredibly broad.
It is. The real legal test is about the relationship. Is the offer being made to people the promoters know personally, friends, family, business partners, or is it being made to strangers?
So it's not about the number necessarily, but about the nature of the connection.
Exactly. Let's look at the first key case, South of England Natural Gas. This one set a very low bar for what constitutes public.
Okay, what were the facts here?
The company printed 3,000 copies of an offer document. They even stamped for private circulation only on them.
So they were trying to keep it private.
They were. And they only sent them to existing members of certain gas companies. They argued, look, this is a very specific limited group. It can't be the public.
But the court said.
The court said it was an offer to the public. Even though the group was limited, the key was that the offer was open to anyone within that class. The promoters didn't personally know all 3,000 of these people. The invitation was general, not personal, even if the target audience was specific.
Wow. Okay, that makes it very hard to avoid the public label. So how do you make a genuinely private offer? This brings us to the other case, Nash v. Lind.
Yes, Nash v. Lind provides the other side of the coin. Here, a document marked strictly private and confidential was sent to just one person who then applied for shares.
And the legal question was, is this one letter a prospectus issued to the public?
Precisely. And the judgment from Viscount Summer is probably the most important quote on this topic. You really need to internalize this.
Okay, what did he say?
He said, anything from 2 to infinity may serve, perhaps even 1. The point is that the offer is such as to be open to anyone who brings his money and applies in due from.
Open to anyone who brings his money. That's the test.
That is the absolute test. A communication that is controlled, specific, and not intended for general circulation, that remains private. It's not an open invitation. This is why a lawyer can share due diligence documents with a client without it becoming a public prospectus.
That distinction is so critical, especially today with digital communication where an offer could go viral by accident.
It is, which is why the strict 200-person limit and the ad ban in Section 42 are so important. They are the modern-day defense against being accidentally deemed a public offer.
Okay, let's shift to some of the specialized ways to issue securities, starting with the offer for sale, or OFS, under Section 28.
Right. The OFS. Remember here, the money goes to the selling shareholders, not the company.
So the logic is, if the company isn't getting the cash, some of the rules can be relaxed.
Exactly. An OFS is exempt from the minimum subscription requirement. It's also exempt from the minimum application value and the need for the board to state how the money will be used.
Because it's not being used for a project, it's just a transfer of ownership.
Precisely. The focus shifts from, is the project viable, to, is the market getting fair access? But transparency is still key. The prospectus for an OFS has to state very clearly who is paying for the costs of the sale and why.
Now let's look overseas. How do Indian companies tap into global capital? Let's compare GDRs and direct listing.
Okay, so global depository receipts, or GDRs, are governed by Section 41. It's a bit of an indirect route. The Indian company passes a special resolution.
75% approval.
Right. And they allot their shares to an overseas depository bank, an ODB. That bank then issues the GDRs, which represent those shares, to foreign investors.
And who votes with the underlying shares in that scenario?
The ODB does. The depository bank holds the legal title and exercises the voting rights, at least until an investor decides to convert their GDRs back into the actual shares.
So how is a direct listing different? It sounds much simpler.
It is. Direct listing cuts out the middleman, the ODB. The Indian company just goes and lists its actual shares directly on, say, the NASDAQ or the London Stock Exchange.
And the benefit there is?
Lower costs, for one. No depository fees. It's also more transparent because the investors hold the stock directly. It's a cleaner, more direct path to global capital, but it does mean the company has to comply directly with all the foreign listing rules.
Okay, so that covers the what and the who. Let's move to the how. The actual process of allotment under Section 39. This is where the deal becomes legally binding.
Correct. The investor applies, which is their offer. The company's allotment of shares is its acceptance. Legally, it's the act of appropriating a specific number of shares from the company's unappropriated capital and putting them in the investor's name.
And you mentioned something earlier. Reissuing forfeited shares doesn't count as an allotment.
No, it's a different legal action. Forfeited shares were already issued once. Finding a new owner for them isn't creating new capital ownership in the same way a fresh allotment is.
Got it. Now, the money. How much does an investor have to put down when they apply?
The rule is quite strict. For most securities, like equity shares, the SEBI regulations say the minimum application money has to be at least 25% of the issue price.
to make sure applicants are serious.
Exactly. It's a commitment. The only exception, as we mentioned, is the OFS. In an offer for sale, you have to pay the full 100% issue price up front.
Now, what happens to all this money? Millions of rupees flooding into the company's account. What's the #1 rule to prevent misuse?
Section 40, subsection 3. It's an absolute rule. All that application money must be kept in a separate bank account in a scheduled bank.
And it can't be touched.
It's completely ring-fenced. It can only be used for two things: to be adjusted against the final allotment of shares, or to be repaid to the applicants if the issue fails. That's it.
And what triggers that repayment? What makes an issue fail?
The big one is failing to meet the minimum subscription. The company states in the prospectus, we need to raise at least X amount for this project to be viable. If they don't hit that target, they can't proceed. The issue is canceled and all the money has to be returned.
So if a company breaks these rules, the allotment is considered an irregular allotment. Let's look at that example. Raksha Detective Instruments Ltd.
A great case study. Raksha only managed to get 80% of their minimum subscription, but they were desperate for cash. So before hitting the minimum and before officially allotting shares, they withdrew half the application money to buy equipment.
A clear violation.
A massive violation. They then went ahead and allotted the shares. A subscriber, Rashmi, found out and refused the allotment.
Was she within her rights to do that?
Absolutely. The moment Raksha used that money for operations, they made the entire allotment process irregular and voidable. Rashmi had every right to refuse the shares and demand her money back with interest. It shows the law puts investor protection above a company's cash flow problems.
And the penalties for these procedural failures are ongoing, right?
Yes. Under subsection 5, it's a daily penalty. A fine of up to 1,000 rupees a day or 1 lakh rupees, whichever is less, for every day the default continues. It's designed to force quick compliance.
Okay, let's take a different scenario. The issue is successful, the money is raised, but then the company's business plan needs to change. What about variation in objects?
This is a huge deal. Investors gave you money for Plan A. Now you want to do Plan B. The law treats this as a major breach of trust unless you follow a very strict procedure.
So what does a company like InSwift Pharma have to do if they need to pivot?
First, they need a special resolution. That's 75% shareholder approval at a general meeting.
And they have to go public with it.
Yes, they have to publish a notice in the newspaper explaining exactly why they need to change the plan. But the most important part is the protection for the minority.
The shareholders who voted no.
Right. Those dissenting shareholders must be given an exit offer by the promoters. They have to be given a chance to sell their shares at a fair price and get out of the company since it's no longer the company they invested in.
That's a powerful protection. And there's one thing the money can never be used for, right?
An absolute prohibition. No matter what, you can never use funds raised from a prospectus to buy, trade, or deal in the shares of any other listed company. It's not a speculative investment fund.
Okay, we've covered the rules. Now for when they're broken, let's talk about accountability and liabilities. The law seems to have a 4-part answer when there's a misrepresentation in a prospectus.
It does. An aggrieved investor has a few options. 1, they can go after the company itself for rescission of the contract and damages. 2, they can pursue civil liability under Section 35. This is for compensation, and it targets the company, directors, promoters, everyone involved.
3 is where it gets serious.
Very. 3 is criminal liability under Section 34 against the people who authorize the prospectus.
And the 4th is a more general remedy.
Yes, a claim for damages for deceit under tort law. But you can't, claim everything at once. Now, about rescission.
Yeah.
It's powerful, but not everyone can use it.
Right. Who's excluded?
Someone who bought the shares on the secondary market. They didn't rely on the prospectus, they relied on the market price. So they can't rescind the original contract.
And the original subscribers to the memorandum?
Them too. They legally committed to the company before the prospectus even existed. So again, no reliance.
The idea of a misstatement isn't just about outright lies. It's about creating a misleading picture. The case of Rex v. Calsant is the perfect example.
The perfect example of a misleading half-truth. The company's prospectus proudly said they had paid dividends every year for a decade.
And that was factually true.
It was. What they didn't say was that the company was making huge operational losses. The only reason they could pay dividends was by digging into old financial reserves and reclassifying them as profit.
So they were basically eating themselves from the inside out to keep up appearances.
Exactly. And the court said that while the statement was literally true, the prospectus as a whole was fraudulent because it hid the truth. The overall impression it gave was false.
This leads us to outright fraud. Section 36, punishment for fraudulent inducement. This goes way beyond just the prospectus.
It's very broad. It covers anyone who knowingly or recklessly makes a false statement or conceals a key fact to induce someone to buy or sell securities, or even to get a loan using those securities as collateral.
So if a promoter lies to investors to pump up the share price, that's Section 36.
Absolutely. And the penalty is the big one. They're liable for action under Section 447, the main provision for fraud.
The Act also goes after people trying to cheat the system using fake names. Section 38, personation.
Yes, this is to protect the integrity of the share register. It makes it illegal to apply for shares in a fictitious name or to make multiple applications under different names to get around allotment limits in a hot IPO.
And the penalty is?
Against Section 447. But the court also gets a special power here. Disgorgement. It can order the fraudster to give up all their ill-gotten gains and can seize the securities. That money then goes to the Investor Education and Protection Fund.
Okay, Section 447 is the hammer of the Companies Act. We have to break down its punishment structure. It's not one size fits all.
It's a tiered system. It depends on the amount of money involved and whether the public interest is affected.
Let's start at the bottom. Tier 1.
Tier 1 is for what we can call low fraud. The amount is less than 10 lakh rupees, or 1% of turnover. A&D, the public interest is not involved. The penalty is a fine up to 50 lakhs and/or jail time up to 5 years.
Now, what if the amount is bigger, but it's still an internal issue?
That's Tier 2. High fraud, but public interest not involved. So over 10 lakhs or 1% of turnover. Here the penalties jump. The fine is up to 3 times the amount of the fraud, and there's mandatory jail time of 6 months to 10 years.
And the most severe tier.
Tier 3. This is when the fraud is large and the public interest is involved. Think of a big listed company cheating thousands of retail investors. The fine is still up to 3 times the amount, but the mandatory minimum jail time is much higher. It's 3 years to 10 years. Involving the public makes the crime fundamentally more serious in the eyes of the law.
That detailed breakdown of liability really explains why so many companies would rather avoid a public issue altogether. Which brings us to the alternative. Private placement under Section 42.
Exactly. Section 42 is the pathway for targeted fast fundraising from a select group of so-called identified persons.
What are the limits that keep it private?
The main one is you cannot offer securities to more than 200 identified persons in a financial year. But, and this is a key technicality, that 200-person limit applies per kind of security. Meaning you could make an offer of equity shares to 200 people and then a separate offer of debentures to another 200 people in the same year.
Are any investors exempt from being counted in that 200?
Yes, and this is a huge deal for the startup world. 2 groups are excluded: qualified institutional buyers, or QIBs, think mutual funds, venture capital, big banks, and employees getting shares under an ESOP.
So you can raise a huge amount from 20 big VCs, and it doesn't even touch your 200-person limit for other investors.
Precisely. That exemption is what fuels a huge amount of venture capital funding in India.
What about the offer document? It's not a full prospectus, but it still has to be pretty detailed, right?
It does. It has to lay out the type of securities, the price, and the justification for that price, how much you're raising, the timeline, and what you're using the money for.
And does every private placement need a special resolution? That 75% vote seems like a high bar.
Not always. For non-convertible debentures, NCDs, if it's within your normal borrowing limits, a simple board resolution is enough. And for big issues to QIBs, you only need to pass 1 special resolution per year to cover all the offers you make to them. It's an efficiency measure.
Now let's talk about the very strict rules on how you can accept the money. These seem designed to create a clear paper trail.
They are. Rule number 1, no cash. Payment must be by check, demand draft, or electronic transfer only.
Rule number 2.
The money has to come from the bank account of the person who is actually subscribing.
That gets tricky with joint holders. You had that example with Rui and Sohit.
Yes, a very specific compliance point. If Rui and Sohit apply for shares jointly, and Rui's name is first on the application, the money must come from Rui's bank account. It can't come from Sohit's, even though he's a joint holder. It's a strict KYC rule.
And just like with a public issue, the company can't use the money right away.
Correct. The funds are frozen until the allotment is finalized, and the return of allotment, Form PAS-3, has been filed with the registrar.
And what if a company tries to get clever and advertise their private placement?
That's a fatal mistake. Subsection 7 is an absolute ban. No public ads, no media, no marketing to the general public. Doing so instantly voids the private nature of the offer.
And the penalty for breaking that rule?
It's severe. The promoters and directors are personally liable for a fine equal to the entire amount raised through that illegal private placement. It's a complete disgorgement of the funds.
Okay, one last area to cover. Brokerage and underwriting commission. There are limits on how much you can pay the people who help you sell the issue?
Yes, and the first requirement is that the payment has to be authorized in the company's Articles of Association.
And where can the money come from?
It can come from the issue proceeds, from company profits, or a mix of both.
And the rate limits.
They're different for shares and debentures. For shares, it's a maximum of 5% of the issue price, or whatever rate is in the articles, whichever is less.
So if the articles say 4%, you're stuck at 4%.
You are. For debentures, the limit is even lower. It's a maximum of 2.5% of the issue price, or the rate in the articles, whichever is less.
And does this commission have to be paid in cash?
No, it doesn't. Based on old case law, like Booth v. New Afrikander Gold Mining Co., the commission can be paid in cash or in kind. So a real estate company could, for example, pay its underwriter with a few flats as long as the value is within the percentage limit.
That brings our very comprehensive review of Chapter 3 to a close. We've gone from the very first decision to raise capital all the way to criminal fraud.
We really have. And if I could summarize the key takeaway, it's this. Understand the structural divide. Public issues are all about maximum disclosure, backed up by the heavy penalties in sections 34, 35, and 447.
Whereas private placements are all about absolute compliance with the strict limits on numbers and the source of the funds under Section 42.
Exactly. The prospectus is a legal covenant, not a marketing brochure. And as we saw with Rex v. Khalsa, you can break that covenant not just by lying, but by telling a misleading truth.
And the tiered penalties in Section 447 show that the law makes a big distinction between an internal mistake and a fraud that harms the public interest.
And for you, the future professional, I want you to think about why these rules exist. The separate bank account, the ban on cash, they are all there to create a clear, auditable trail. Your job isn't just to file the forms correctly, it's to protect the integrity of that entire process.
Speaking of integrity, this whole chapter is a balancing act, isn't it? A company's need for capital versus investor trust. We talked about how critical the definition of public is and how QIBs allow for massive private fundraising.
So here's the final thought I want to leave you with. If a company needs to raise a huge amount of money fast, a public IPO has obvious legal and compliance headaches. But think about this. Does the private placement route, while faster, actually demand greater internal discipline?
Because of the rigid 200-person count, the strict payment rules, the zero-tolerance policy on advertising?
Exactly. You must always analyze the class of your investor before you decide on the mode of the issue. That choice determines whether your compliance headache is external-facing SEBI scrutiny or internal, managing the tight controls of a private deal. And that regulatory burden is just the price you pay for building trust.
Thank you for joining us on this deep dive.
We hope this structured approach helps you master your future practice.
We'll see you next time.
Don't forget to like and subscribe.